So dramatic. Hello, it's that time of the year again when my legal profession and my very small niche of the royal family on YouTube intersect. I actually really enjoy making these videos, so Dragon Slayer Harry, please, onegaishimasu, do not stop suing the media. Although, with the costs order coming his way, it's over. My apologies for coming late to the party. When it comes to this case, I did have to read through over 400 pages and it was not fun. But I wasn't the only one not having fun because Prince Harry is clearly very upset. Last week it was announced that Prince Harry lost his case against ANL dismally. When I say lost, I mean on every single count. Really long-term subscribers. I'm talking OG people who have been following me since 2020 when I started, and I started covering Johnny Depp's defamation case in the UK. You'd remember how I was very pro David Sherburn, you know, Prince Harry's lawyer, who was also Johnny Depp's lawyer. My goodness, was I young and naive. Because as I was reading through this judgment, I was left scratching my head, wondering how David and his team even got their practicing licenses in the first place. It's that bad. It's that incompetent. It's that embarrassing. It only serves to prove the stereotype that lawyers are all corrupt and they'll just take on any case for money. And I say this as a lawyer who will not take on any case for money. So as a part of the younger generation, you know, we're meant to look up to these people. Whoa, we got nothing to look up to. Now, luckily for me and for you, this judgment was actually pretty repetitive because the same mistakes were made with respect to every single allegation. So Prince Harry referenced 14 articles or relied upon 14 articles to prove or allege that ANL used illegal information gathering practices to not only violate his privacy, but publish his private matters. And he failed on every single count. And by the way, he wasn't the only one. I know I'm not covering the other claimants, but they all failed on every single count. How this case even got to trial is beyond me. But I'm getting ahead of myself. So let's start from the beginning. I'm not going to give you, any detailed overviews or summaries or whatever. This case has been going on for, I think, the better part of 4 years at this point. It's been going on for a while. I'm going to focus on just exactly what you need to know, what they're alleging, and why they absolutely failed. Prince Harry is alleging that from the early 2000s up until the late 2010s, ANL used illegal information gathering practices such as phone hacking, blagging, phone tapping, and hiring third-party investigators to not only violate his privacy, but to then feed that information to reporters who worked for ANL and publish it in the form of articles. They further allege that ANL went through great lengths to conceal this wrongdoing. And this is relevant to the statute of limitations, also known as the time period within which you can bring as a claimant a cause of action. You can sue someone. In this instance, the statute of limitations is 6 years. Now, obviously, 6 years ago was 2020. So all of this happened long before then, but they're claiming that, well, ANL concealed this wrongdoing, and therefore we were not made aware until later on. I believe it was 2019, Harry alleges, 2018, when he went to France and David Sherburn told him, hey, this has been happening, by the way, did you know? What we all must understand is the central issue that was being tried in this case, which is whether Prince Harry has proved on the balance of probabilities. That's the standard of proof for civil cases. So at least a 51% chance or more that the information contained in these articles he's relying on were obtained by ANL reporters through illegal means. It's not a breach of privacy case. It's a case of whether that information was obtained legally or not. This is where the problems start. Harry's strategy appeared to be the following. He wanted the court to infer from the very private information contained in these articles that they were gathered illegally. So he wants the judge to draw a connection. Now, inferences can be made. In fact, the judge makes many inferences here in favor of A&L, for instance, or the witnesses, the reporters who testified. But that is often not enough. You need evidence to support your claim as well. And believe me when I tell you that Prince Harry provided nothing, nada, zilch, zero evidence to support his allegations, which is obviously very problematic since in the UK, in such cases, the burden of proof, different to the standard of proof, the burden of proof falls upon the claimant, being the Dragon Slayer himself. As I mentioned, there are 14 articles that Harry relied on, with the first one having been published on the 2nd of September 2001, and the final one on the 27th of December 2013. Initially, I thought I really had my work cut out for me. I had to read through every single article excerpt and see what was wrong and what evidence was provided and for and against. But it turns out that, I don't know, maybe Prince Harry's team, they're insane or something, because, you know, the definition of insanity is doing the same thing over and over again and expecting a different result. Yeah, that's pretty much how this judgment read. Article 1, 2, 3, 4, bam, bam, bam. No evidence, no evidence, no evidence. And equally as troubling, no specific mode of the illegal information gathering was specified. And what I mean by that is you have to be specific when it comes to your pleadings. The civil procedure rules are quite clear about that. You're not meant to be providing evidence or anything in your pleadings, don't get me wrong, but you're meant to at least be saying, hey, these are the facts and this is why it's wrong. But Prince Harry never specified what they did. What was the illegal mode, the medium that they utilized to get this information that was otherwise allegedly private? And when it was done, by the way, it wasn't in the pleadings. What they did time and time again, which the judge really did not appreciate, was bring up new allegations, new specific accusations, such as voicemail interception, that was their favorite, during cross-examination. Right there. Just out of the blue, without putting the other side, the defendant, on notice so they can adequately prepare to defend that allegation or accusation. And this really did not bode well for them, because that's simply not how the law works. And this is where I come back to, what kind of lawyers are these people? But this is what the court had to say about it. The court must determine the case that was pleaded, meaning in the pleadings, not a materially different case developed during cross-examination or closing submissions, which is even worse, just bringing up things randomly during closing submissions. All right, so in the list of seemingly infinite wrongdoing that was committed by Harry and his team, their pleadings were not particular, and they basically had no evidence, and then they threw in random allegations just in the middle of the trial, at the end of the trial. But the fatal, now we know, to the case, mistakes continue. Not only did they not specify what mode of illegal information gathering they were relying on, but the pleaded case was, as the court states, strikingly general. This is in relation to an article from 2004 written by Rebecca English called How Harry Fell in Love. The court states, in his pleaded case, Prince Harry identifies the relevant information simply as details of his relationship with Chelsea Davy, including as to their plans. Elsewhere in the amended... No, I am not a DJ as a side hustle. Literally, this is how it was written. That's how many amended claims Prince Harry put in. But in the amended particulars of claim, the claim is advanced by reference to A&L's alleged habitual use of unlawful acts. But the pleading does not identify, in relation to the article itself, any specific act of voicemail interception, blagging, flight blagging, or other particularized mechanism of UIG, which is basically just the illegal information gathering. And this, I could just copy and paste the judge's remarks here to almost every other article. I will point out there was one article which still failed, but it was the strongest piece of evidence, if you can call it evidence, Harry presented. And that was Article 11. Harry takes Chelsea on a make or break holiday. Now, in this article too, no specific mode of illegal information gathering was pleaded. But there was an email, which was hearsay. Hearsay evidence, as you all know if you're regulars of this channel and you've been paying attention, or if you're lawyers yourselves, is quite unreliable and at many times inadmissible in a court of law, because it's basically an out-of-court statement. You've heard me say this at least 100 times before if you've been here a while, that is being introduced to court to prove that something is either true or false. So someone told me this. It was a statement that was made out of court, not under oath. An email is, yes, a written statement, but it was made out of court. So they're not reliable. There are ways to introduce them. You bring in the author of the email, for instance, to verify what they'd said under oath, but it doesn't seem that Prince Harry and his team went that far with this particular email. Now, this email was sent by a very suspicious character who actually does have a tendency to illegally gather information. And the judge did take this into account as propensity evidence, which, as the name suggests, is evidence that is introduced to show that this particular witness or party to the case has a propensity, has a tendency to do these things. Now, this email was suspicious because it contained incredibly detailed information about a flight that Chelsea Davy had taken, right down to her seat number, which we can all agree is not readily available information. The problem is that email had nothing to do with the trip that Harry and Chelsea were taking together. That flight was actually a flight she had taken to spend time with her family at a completely different destination. And so the email, while it did raise a prima facie case of illegal information gathering, unfortunately fell apart as soon as that link between the article, the information contained in the article, and the email collapsed. The article was about spending time with Harry. The flight and the email were about Chelsea spending time with her family in a separate destination. So it automatically failed. I also want to note that in every single article, so all 14 articles, all the reporters had sources that they could, if not name, at least identify and use contemporaneous notes they'd made while researching for the articles, even if it was just through nicknames, code names to protect their sources. For instance, in this particular article of Chelsea and Harry going on holiday, Rebecca English had contacts at Leeds University where Chelsea studied. Apparently, friends think it's okay to talk to reporters and get paid to provide information, not illegally. When you're someone's friend, you kind of know things, right? You know where they're going on holiday, you know what Prince Harry told her the other day, etc., etc., etc. Girls talk, they gossip, and reporters know this. In fact, a further piece of evidence that supported A&L's case is the fact that Rebecca English had made a £200 cash payment, which she vaguely remembers as being possibly for one of these students. And it lined up because this blagger, this person who is a shady character and has a propensity to commit illegal information gathering acts, has a day rate. He's not just paid by, here's some cash under the table. And the judge found that to be convincing. He also found Rebecca English to be quite an honest and impressive witness. I will remind everyone that this is a case of on the balance of probabilities. This is not beyond a reasonable doubt. It's a much lower threshold, which really shows you all the more how poor and how weak Harry's case was, along with the other claimants. And why I'm reminding you of this is because the judge is free to sit back and assess which side is convincing him more. That's not corruption. It's corrupt when, it's plain as day and you're left wondering what on earth just happened, which is how I felt when Johnny lost his case in the UK. But you know what? Upon reconsideration, they say hindsight is 20/20, haha, pun unintended. I'm starting to think Johnny lost because David Sherborne was his lawyer. I said what I said. The court summed it up beautifully, so I'll just hand it over to Mr. Justice Nicklin, using my voice, of course, but his words. In substance, the claimant's case invites the court to conclude that because the information was private and because Associated cannot positively explain how it was sourced, the article must have been unlawfully sourced. That is not a permissible approach. In my own words, I think the judge was being very charitable here. The way I would frame it is Prince Harry thought that because I said so is a valid and sound legal strategy. Enough to win him this case and every other case he's attached his name to. That's honestly my summation. Because I said so. I want to close off by saying that I was disgusted by the lengths that some of these reporters would take just to write, a piece of tabloid trash, talking to kids, like kids' friends. Harry and Chelsea were very young when this was happening. And for grown reporters to go to universities and befriend these kids and pay them just to get a story is morally reprehensible in my books. But unfortunately, as the judge repeatedly has said, this is not a case of whether this was morally wrong. This is not a case of determining whether the information was private. This was a very specific case, which was to determine whether the methods utilized to obtain this information were illegal or not. That's how court cases work. They are very specific, and the court is bound by that specificity, by what's been pleaded by the claimants. If the court oversteps, then it risks an appeal. It risks the defendant in this case appealing and going, the court completely overstepped its jurisdiction. It completely overstepped the boundaries of the case and what it was required to determine. My advice to Prince Harry, if he's going to keep suing, first of all, please do, so I can have interesting content to cover on the channel. But maybe it's time you found different lawyers. That's all I have for you today. I hope I helped clarify what exactly went wrong. Oh, actually, before I forget, apparently Harry tried to settle and A&L said nope. Should have thought about that sooner, I guess, because A&L did try to get this case dismissed very early on. And I do wonder how it made it through. I really do. I think the judge probably thought, I'm just going to give them a chance. Yeah, the pleadings, the claim is vague, but perhaps in discovery, perhaps in trial. Surely they have some tricks up their sleeves. No, it was as bad as it seemed to begin with. But, hindsight is 2020. And I suppose the judge couldn't have known. But a very hefty costs order awaits Prince Harry and the other claimants, because in cases such as this, costs follow the event. The loser pays the other side's costs as well, in addition to their own. Very bad news for Prince Harry, but he made his bed. Now he has to lie in it. Let me know what you all think of this case. And if you appreciate what I do here on the channel, do consider visiting the link to Patreon in the description box below. I put ad-free versions of all my content, and a little help goes a long way, and I'd very much appreciate it. If you cannot, you know the drill. I will still as long as you support us for free here on YouTube. I mean, come on. Love ain't so free. What am I doing? Okay, I'm gonna stop now. It's a Sunday. What am I doing? All right, enjoy your Sunday. You're gonna see this on Monday. I hope you enjoyed your Sunday. Enjoy the rest of your week. I'll see you next time.